Monday's listening ability under the watchful eye of the International Court of Justice at The Hague may have all the earmarks of being a triumph for India as far as political focus is scored back home, yet there were some key legitimate issues that Pakistan pointed out that require our thought. The lawful issues come from the way that there was a 2008 reciprocal concurrence on consular get-to. An ascension that India looked for not to depend on at The Hague on Monday and only confined itself to the Vienna Convention on Consular Relations. In doing as such, India made the point that the ascension had not been enrolled with the United Nations and thusly, India would need to confine the contention to the Vienna Convention on Consular Relations alone. This might be the main occurrence of a state repudiating a respective arrangement, as per which it has been acting, amidst a court continuing. The ICJ is not a common court in the strictest sense. The ICJ is a political body and articulations made before the ICJ have outcomes. Which is the reason states are spoken to by operators who train direction to contend the case for them, as opposed to simply guide alone. Explanations made by an operator or a specialist by means of their guidance tie the state in the universal fora. By declining to recognize the 2008 agreement, India could have well recently ended that ascension. The understanding is basic for the destiny of numerous Indian anglers who wind up straying into Pakistani waters a seemingly endless amount of time as it required the trading of detainee records and consular get-to. Harish Salve at the ICJ. Picture credit, webtv.un.org. Harish Salve at the ICJ. Picture credit, webtv.un.org. Getting to the meaningful part of consular get-to, one of the key contentions that Pakistan raised under the steady gaze of the court was that India had neglected to demonstrate the nationality of Kulbhushan Jadhav. While to numerous this may appear like a detail, it is definitely not. On account of Mexico versus United States, the case concerning Avena and other Mexican nationals, all the more usually the Avena case, the ICJ was very evident on the point that altogether for a state to practice conciliatory insurance, it must demonstrate that the individual it is attempting to insure is a national of that state. Pakistan brought the question up in court on Monday, as India was not managing the Indian travel permit with which Jadhav was found. While there is plenteous proof that may exist to demonstrate that Jadhav is an Indian national, this confirmation was not put under the steady gaze of the court. Rather, India depended entirely on Pakistan's affirmation that he was an Indian spy. In the event that we are questioning the Pakistani story of things, it winds up plainly officeholder upon India to demonstrate that the Pakistani account is false. Towards this, among the many adds in India's pleadings before the ICJ, attaching Jadhav's introduction to the World Declaration or maybe a duplicate of his unique international ID would have gone far in countering this protest by Pakistan. Put just, not all spies are of an indistinguishable nationality from the state for which they are spying. Once in a while outside spies can be locked into, think James Bond and how he generally had somebody nearby functioning for British intelligence in the event that you have to comprehend it essentially. Despite everything we have a way to demonstrate he is a national of India. The other is the ground of purview and reliefs. India has drawn closer the ICJ to request that Pakistan discharge Jadhav because his rights under the Vienna Convention had been abused, or in the option, to announce that the military court trial was out of line and not done as per international law, and request another trial alleviation by method for compensation in integrum, which is legalese for coming back to the first condition. This turns out to be exceptionally risky in light of the statute of the ICJ and specifically the way that the ICJ is a body for the pacific settlement of debate amongst states and not people. The Vienna Convention does not accommodate the privilege to reasonable trial. To be sure, the privilege to reasonable trial, despite the fact that perceived under international law, is not one that is justiciable before the ICJ for a situation where the Vienna Convention has been broken. Give us a chance to take an illustration. Tomorrow, if an Indian were to be put through the kangaroo courts of North Korea and sentenced to death, if India had consular access to that Indian, there is valuable little India could do to have that trial put aside, as North Korea has the directly under international law to run its issues as per its sovereign rights. Presently, if the last alleviation is one that the court can't concede, then break help is something the court might be probably not going to give for this situation. In the Lagrand case, Germany versus United States, the court held that as a method for compensation, a full new trial require not be given and truth be told, regardless of the possibility that audit and re-evaluation considering that consular get-to was not given would be adequate alleviation to compensation in integrum. By saying this, the court declined to audit if the trial had been reasonable or not, and as far as the alleviation held that survey and re-evaluation alongside pardon might be legitimate methods for cure as opposed to putting aside the trial itself. See para 141,142 and 143, saying on the purpose of a pardon methodology. The court considers in any case that proper leniency techniques call supplement legal audit and re-examination, specifically where the legal framework has neglected to assess the infringement of the rights put forward in the Vienna Convention, as has happened on account of the 3 Mexican nationals alluded to in passage 114 above, para 143. It would be savvy at this phase to bring up that India, in none of its pleadings under the steady gaze of the court, has requested consular access as a petition, incorporating into its primary supplications under the watchful eye of the court. None of them incorporate a help by method for a course that Pakistan give consular access to the Indian national concerned, which is the alleviation to address India's essential and proceeding with grievance under the Vienna Convention. Consular get-to would help Jadhav discover legal counselors to battle his allure and furthermore help him contact with his family back home. The essential point of the Vienna Convention is to encourage those rights. In any case, in the reliefs looked for before the ICJ, India has not requested consular access to be allowed either as a last or as a between-time help. To wrap things up, India flopped hopelessly on Monday to set up desperation under the steady gaze of the court. The odds of its between-time application being permitted to a great extent vanished when Pakistan consented to agree to an early hearing for speedy transfer of the matter. In all past cases there was significantly more desperation before a state went to the court. In the primary instance of this kind, Paraguay versus the United States, Paraguay moved toward the court on 3 April, 1998 when the execution date for its national was set for 14 April. 1998. There were around 2 weeks to go. Record picture of previous Indian Maritime Officer Kulbhushan on Jadhav. Profile picture of previous Indian Maritime Officer Kulbhushan Jadhav. PTI. In Lagrand, Germany versus United States, the execution was booked for the next day, and in the Mexican case, there was around a month. In the event that Pakistan can build up that Jadhav won't hang inside the time that the case could be heard and arranged off by the ICJ, then there is no way of India getting a break measure. Pakistan could do as such by indicating out that there was still time before the execution, and accordingly the court require not mediate. Give us now a chance to return to the key truth that the ICJ is a conciliatory body and not a court essentially. It exists to have states settle debate calmly as opposed to go to war. The court will be hesitant to meddle in the inner workings of a state unless it needs to. This is the reason India likewise barely ever goes to the ICJ to dispute. Very likely, this is the first run through India has connected as a candidate to the court to look for substantive help. The last time India was before the ICJ as a candidate in 1971 was the point at which it tested a choice by the International Civil Aviation Organization in light of the fact that it didn't have purview. It has been predictable Indian strategy to have illicit relationships settled reciprocally instead of summoning the ward of the ICJ. Which makes this creator ask why India has all of a sudden chosen. The Vienna Convention is an exceptionally strict tradition. It requires that the individual captured be educated of their entitlement to consular get-to, and furthermore requires that this get-to be provided at the soonest. Tomorrow, if a psychological oppressor is gotten in Jammu and Kashmir, and the experts neglect to illuminate him of his consular rights, Pakistan could all of a sudden make an application against us before the ICJ. Respective relations work better for states that offer long fringes and continue confronting the issue of nationals slipping in starting with one domain then on to the next. To conjure a multilateral structure and in the meantime deny a two-sided one is something that India has at times done. After Monday's listening ability, one truly thinks about whether the guidance of the legitimate mandarins in the Ministry of External Affairs is being noticed, or if India is simply moving this case thus of a political choice.